clarifying asset ownership. These agreements create clear guidelines for asset ownership during marriage and in the event of divorce, separation, or death. And they just define assets. So they define assets with regard to what's marital property or community property in Washington state that would be subject to division if there was a matrimonial action like a divorce or a separation, and what is separate. And it's critical for estate planning purposes because it shows and informs how assets are going to be used or distributed at death. And so knowing this is our community asset and this is our separate asset can show, I've got control over this asset as far as when I die, it goes this way because I say it does it, and it's my asset, and I'm the only one that has control over it, okay? Whereas with marital or community assets, you've got right.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth. Pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning and probate attorney from Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas include estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning is often a confusing and complicated topic, but my goal with this podcast is to make it understandable and accessible to those who need it. So if this is something that interests you, I'd appreciate it if you click the subscribe button and like this episode so that you can follow along as we break down the barriers to estate planning. I'm excited to get to today's topic. Today's topic is pre- and postnuptial agreements. What are they and how do they fit into an estate plan? Because pre- and postnuptial agreements can be a critical element of a robust estate plan, particularly in certain cases. So on today's episode, we're talking about pre- and postnuptial agreements. What are they and how do they fit into an estate plan? So let's get to it. Prenuptial agreements can get a bad rap, and they're often misunderstood. Did you know that there's also postnuptial agreements? If you're not an estate planning junkie, I guess, or family law junkie, I guess in that case, you probably don't, right? Probably not. But postnuptial agreements, I guess, are the same thing as a prenup, except for they're executed after the nuptials, so after they're married. In many cases, in today's blended family environment, both a prenup or a postnuptial agreement can play a significant role in making sure that your estate and assets are protected from the dreaded D word, and we're not talking about donkeys. I have many clients that use pre- and postnuptial agreements in their estate plan. The goal isn't to cut out the new spouse as much as it is to keep in the new couple's children or previous children from previous relationships and other family members. Prenuptial and postnuptial agreements are not punitive, but prescriptive. They set the standards for the worst case scenarios with married and blended families. I did another episode on this topic, blended families, a few months ago. It's episode 13 if you're wanting to check it out. It probably came out in February. It talks about things to consider if you have a blended family, including prenuptial agreements. So if you want to check that out, that's a good one to take a listen to if this is an interesting topic for you. But this topic has been coming up a lot lately in my office. It sort of goes in spurts, and maybe it's because it's spring turning to summer and people are starting to think, well, maybe we're going to get married this summer, and it comes up. So I thought it was time to do an episode where we talked about prenuptial agreements and postnuptial agreements as well. So today we're going to talk about what they are, for one, and then we're going to talk about 10 ways in how they fit in with an estate plan. Okay, so let's start with what is a prenuptial agreement. Okay, so prenuptial agreement is a legally binding contract So like anything with estate planning, it's a legally binding contract. It's this written agreement between two individuals before they marry. So a prenuptial agreement typically outlines the rights and responsibilities each person in the relationship has concerning property, assets, debts, and other financial matters in the event of a divorce or death or a separation. Okay? And in order for them to be valid, they have to meet certain requirements. Like any legal document, they have to meet certain legal requirements. Generally, they have to be signed. They have to be voluntary by both parties. And if it's a prenuptial agreement, it has to be executed prior to marriage. If it's not, it's called a postnuptial agreement. And these agreements are enforceable by the courts. They're varying levels, and it's dependent on certain factors in how these agreements are come up with. Okay? So their enforceability may be subject to a review based on factors like fairness, full disclosure of assets and full disclosure of debts, the absence of coercion or duress during the agreement's creation. Usually with my clients, I'll have them definitely say, hey, your fiance needs to get their own lawyer to explain this to him, to lay out everything that it says, the pros and cons, the ups and downs, and, sign off on it with them. So usually with the agreements that I do, we'll have two lawyers, me and another attorney, sign off on this agreement that we've told the client, this client sign off that they understand it, and then they sign off to agree, right? And there's certain things you want to not do when you get a prenuptial agreement or when you're presenting it to your new spouse, potential spouse, I guess I should say. It's like, hey, we're just doing this for the lawyers. I'm going to take care of you. Don't worry about it. That's something you don't want to say when you're doing a prenuptial agreement with someone. We're just as a formality. It's not going to change anything between us. Those are things that you don't want to say, right? I'm taking care of you. That kind of stuff can lead to bad things as far as enforceability of these agreements. So anyway, but basically they lay out this couple's assets. They lay out the couple's debts. They talk about what's going to be community property. I'm in Washington, which is a community property state. So things that are acquired during a marriage are considered community property typically. And things that you own before marriage are typically considered separate property. And other things that can happen, like inherited money, can be considered separate property by default, by rule. But that kind of stuff is laid out in there. What happens if we get divorced? What happens? Sometimes there's different tiers as far as we've been together 5 years, 10 years, 50 years. They have different tiers as to like what happens with the distribution of the estate. So we're going to talk about, now that we've sort of gone through what a prenuptial agreement is, and I guess for completeness maybe, the postnuptial agreement basically does the same things as a prenuptial agreement, but it comes later, right? It comes after someone or a couple's married, and they're usually just as enforceable as a prenuptial agreement, typically, I'd say. I'd probably recommend, if you're going to do an agreement with regard to your marriage, it would be better to do a prenuptial agreement, because I think that would have a little bit more teeth than a postnuptial agreement, especially if it's been, that you've been married for a while. It might not be as effective to use a postnuptial agreement as opposed to a prenuptial agreement. So now we're going to get to the points here of how this prenuptial or postnuptial agreement can be integrated into your estate plan. So I've got 10 points as normal. I'm seemingly doing 10-point plans or talking points on all these episodes. Maybe not everyone, but we've got 10 today for you. So hopefully that's good for you. So number 1, asset protection. So the main reason we do prenuptial or postnuptial agreements is to say, I've got all this stuff and I'm getting married to someone who may not have a lot of stuff or may have their own stuff that they want to protect. And I want to make sure that if something happens between us, my stuff is separate from our stuff. Okay. And so they basically designate certain assets as separate property, ensuring that they remain with the original owner in the event of a divorce. And it's also important to preserve those assets for intended beneficiaries down the road, particularly children from a previous marriage or relationship, or other family members that might be wanting these assets. A lot of the time, a business is an asset that is part of a prenuptial agreement. If a person had a business prior to marriage, oftentimes they want to have that business be separate property. So if they have children or partners or friends that are working in this business, they want to be able to give that business to them, right? Maintain this business for their benefit, not have an outsider, with air quotes if you're listening, involved later. Okay. Number 2, clarifying asset ownership. These agreements create clear guidelines for asset ownership during marriage and in the event of divorce, separation, or death. And they just define assets. So they define assets with regard to what's marital property or community property in Washington state that would be subject to division if there was a matrimonial action like a divorce or a separation, and what is separate. And it's critical for estate planning purposes because it shows and informs how assets are going to be used or distributed at death. And so knowing this is our community asset and this is our separate asset can show, I've got control over this asset as far as when I die, it goes this way because I say it does it, and it's my asset, and I'm the only one that has control over it. Okay? Whereas with marital or community assets, you've got the right to distribute half or allocate half or bequeath half of a marital asset or community asset, but not 100% of it. And so clarifying asset ownership is important. Number 3, estate planning flexibility. So by defining property rights and spousal interests, pre- and postnuptial agreements provide greater flexibility in estate planning. They allow people to allocate assets according to their wishes rather than based on the default state rules or state laws, okay, regarding marital property. So it basically can circumvent state law by agreement. It's not going to be in contravention or contradiction of state law, whichever that word is. But it's going to lay out how these things are going to happen. Like the default things that happen in a divorce would no longer be default, right? Because the pre- and postnuptial agreement will lay that all out for the couple, okay? Which gives you a flexible estate plan because you can allocate assets as you wish, right? And knowing that this is going to be mine even if this doesn't work out. Number 4, creditor protection. So you may not think that creditor protection is an advantage of having a pre- or postnuptial agreement, but it really can be. So in Washington state, for example, assets of a marital couple are community assets. So assets that are acquired during marriage are community property. That's the law. Okay. And so oftentimes, say for example, and this also applies to like debt. Okay. So debt that you have before you get married is considered separate debt. Debt acquired during the marriage is community debt. And so in Washington, for example, when, say for example, you have like one of the spouses gets in a car accident maybe, or has a credit card bill that's in collections or something like that. Some kind of creditor comes after someone. In Washington, oftentimes they'll name the spouse, Bob Smith, and Jane Doe Smith, the spouse, and their community estate as the defendants in this lawsuit. So they're coming after both the community estate. So by making sure that things are considered separate or community property, we can preserve the separate property from lawsuits like that, right? Collection actions like that, where they're trying to go after the community estate. But if it's separate asset that's not a community asset, that would not be subject to a collection action on a credit card or a judgment or something like that. And so it protects the assets that you came in with from being subject to your new spouse's creditors. Number 5, preserving family inheritance. These prenuptial or postnuptial agreements can safeguard family inheritances by specifying how certain assets will be treated in the event of a divorce or death. We've said that before, right? They can ensure that inherited assets remain with family and not get mixed up with other assets, right? They could stay with the line of the family lineage, and they wouldn't be subject to divorce. So that basically means that we don't have any unintended distributions. Everything is specific, okay? Everything's dialed in. Number 6, avoiding disputes. Well-drafted prenuptial or postnuptial agreements can prevent disputes among heirs by clearly outlining asset ownership, and it can minimize the potential for disputes later when everything's laid out, right? If you come into a prenuptial agreement or postnuptial agreement, everything's on there as far as I have this account, this piece of real estate, this insurance, this car, right? This business, and it's dialed in, right? Everything, we know what it is, where it goes, whose it is. And because of the agreement says, well, if this happens, if we get divorced, this is what happened. We know what's going to happen with those assets. And so that means you can basically, so here's the goal, right? The whole goal with this estate plan business is, for me, to avoid disputes later, right? Resolve issues now before they become problems later. So by laying out that plan and the allocation of assets, avoids disputes later because it's all there. It's all set in stone, right? Number 7 is streamlining the probate process. So this goes back to like the community versus separate. So if we have assets that are separate property, they wouldn't have to be done through a community probate, right? They wouldn't have to be administered under a community probate. So if one spouse had a, say for example, a lot of the times people do this, and I actually had a couple come in this week and we did 2 separate trusts for them. They're a second marriage couple. They've got separate assets. We did a separate trust for each one of them, and they're going to hold their assets in these separate trusts. And so if they had a prenuptial agreement too, which they don't, I don't know if they're going to do that. They're not going to. I don't. Anyway, but if they had a prenuptial agreement that said, well, this car that I brought into the marriage, it's a collectible Mustang or something, I don't know, is my separate property. So if it's outside of the estate or outside of the trust and they had to probate that asset, that Mustang, then it wouldn't have to be a joint probate. It could probably just be for that one spouse, because we know that separate asset, that's a separate property asset. It's not going to require 2 probates. Number 8, addressing children from previous relationships. So for people that have children from previous relationships, like I mentioned in the beginning of this thing, we want to make sure that these kids or children, maybe now adults, are part of the estate plan still. One of the biggest things, and I talked about this in my episode 13 about blended families, is, well, I've got a new wife, and so I'm going to update my will, and I'm going to give if I die first, I'm going to give everything to her, and then when she dies, it'll all go to my kids. And so the problem with that is when the surviving spouse gets all that money, it's hers. You know, she doesn't, it's not if it's in that structure where it's like an outright distribution, there's no trust for her. That money will go according to what her will says. And her will probably says, well, give everything to my husband if I die first, but if I don't, then give it to my kids. And so that means if she dies second, she's the surviving spouse, all of the deceased spouse's stuff, the husband's stuff, goes to her kids, and his kids get cut out. And so the prenuptial or postnuptial agreement integrated with an estate plan for a blended family can really coordinate how things are really going to be distributed, so that the kids from previous marriages aren't kicked out, right? They're not like written out intentionally or unintentionally in an estate plan. It's just sloppy. And you see a lot of sloppy estate plans, and it's just something that comes up. And it's often where you do your own will, or maybe you go to an attorney that does everything that walks through the door, and they're not estate planning attorneys, so they don't see it all, right? They don't think about all the issues because they don't see them, which is fine. And so with a blended family, we want to make sure that we're addressing these old children and also potentially new children. So that was number 8. Number 9 goes along with number 8, maintaining family harmony. Being open, communicating about what's going to happen in these kinds of scenarios. If we get divorced, we get separated when I die, it just breeds family harmony, right? It just breeds like, okay, I don't have to worry about this because mom and dad already talked to me. I know dad married a new wife and I like her, okay, but she's not my mom. But dad's trying to take care of me. We've talked about it. I know what's going to happen. We've talked about it, right? So if we address potential areas of confrontation up front, couples can build trust and understanding amongst themselves and amongst the kids from previous marriages. And so that's much more beneficial for long-term dynamics of families. And then number 10, as with everything in estate planning, we want to make sure this thing's up to date. We want to review these documents. We want to review our pre- or postnuptial agreements just to make sure that they're still in line with what we want to have happen. Okay. These things that we look to for review are almost always the same. Family changes, new assets, new financial circumstances, changes in marital status. Those are all the things we want to look at and review our documents in those times. And so keeping the documents current ensures that they are effective and align with what the goals are. We just talked, last week's episode talked about estate planning not being a set it and forget it endeavor. And so if your estate plan includes a pre or postnuptial agreement, you want to make sure that those still align with your goals. Okay. As with the rest of your estate plan. So don't set it and forget it. Okay, so now we're toward our story time. We got through our 10 points. It says for story this time, you probably think this is going to be different than what you might think of a prenuptial agreement story. Okay. You're probably thinking that I talk about some rich old dude that marries a younger woman and he wants to keep all of the assets away from her if things don't work out, right? I don't want to have her take all my stuff, right? And there's a lot of those, right? There's a lot of those scenarios, and they probably are the most common prenuptial agreement scenarios where a rich old guy is married a younger girl and keeping his stuff safe, right? He's got all the assets. She doesn't have much because she's so much younger, or vice versa. It could be an old rich lady and a younger guy. Okay, that goes both ways. And this happens both ways. I've got clients on both sides. But I thought I'd give you this scenario, this story for today's episode. I have this longtime client, we'll call her Barbara, and she and her husband did their estate planning with me over the years. We did several different versions of a trust and, made sure that their estate plan reflected their wishes. And they were married for over 50 years when her husband passed away. And they had significant assets, right? They had real estate and investments. And we set up their estate plan so that it distributed without having to deal with probate. And we allocated assets so that they'd be able to take advantage of their estate tax credit and not pay estate tax, ideally. But then Barbara found new love. She met somebody. And it's a positive for her. She's very happy, right? So in this case, she met with me. She said, James, I don't know anything about prenuptial agreements, but I think it might be a good idea. What should I know about them? And so she asked, how can I use one of those to fit into my plans if I end up marrying this guy? And both of these folks are over 80, right? They're in their 8th decade of life, or 9th maybe. They've had 8, they're going into their 9th. And they want to be happy, but they want to make sure that their kids, they both have kids from previous marriages, and they want to make sure that their kids aren't cut out and that their kids really get their stuff. Neither of them need each other's stuff. And that's another reason why people do prenuptial agreements is, well, we're both fine. I don't need your money if you die, or you don't need my money if I die. So let's just make sure that we have things split to our kids. And so, neither of these, Barbara and her new fiance, don't want anything from each other when they die or if they divorce. And so Barbara's prenup's going to basically be related to protecting her assets for her children and her estate, so that if something happens, these worst case scenarios that we're dealing with don't cause a major problem, right? We're talking about worst case scenarios and all this stuff, right? Ideally, everybody lives happily ever after, and we don't have contested wills, and we don't have contested trusts, and we don't get divorced and all these things, right? But these things happen, and so we want to make sure that we have these scenarios played out before they're being played out in the battlefield. Let's plan them in a boardroom or a conference room before they have to be played out on the battlefield, right? If you want to take that analogy. Okay, so last week I introduced an In the News segment on this podcast, so I'm going to do it again. We're back into the In the News segment of this episode, and so I thought I'd check out some things, right? I'd check out interesting stories that I can share in the podcast once a week, just that are going on with estate planning or regarding estate planning. And so I was looking around. I saw this story this week on investmentnews.com, and I thought it was interesting. It goes along the lines of what we talked about last week with regard to getting their estate planning done. And this story talked about a recent survey that was done by a company called Free Will, which is it's a company focused on philanthropy and estate planning. Okay. And according to this poll, which was based on 2,000 people, adults, 69% of Americans agreed that estate planning is at least somewhat crucial, but only 26% have taken any steps to formulate a plan. So 69% of people think it's important, or at least a little bit important, but only 26% have taken any action towards it. And so this is something too, and I think I know this through my years of being an estate planning attorney. Financial advisors are the key agents of change with regard to getting estate planning done. So it says respondents who said they work with a financial advisor are reportedly 4 times more likely to have an estate plan compared to those who don't. So 65% versus 17%. An overwhelming 90% of individuals working with advisors also acknowledge the importance of estate planning, outpacing the 65% of those without financial advisors. So people working with a financial advisor are much more aware of it. And I think it's because financial advisors counsel with their clients as well. And they talk to them, hopefully quarterly at least. And they say, hey, have you got your will done? Have you got your estate planning done? And good financial planners have relationships with estate planning attorneys that, work together, right? So I have many financial planners that I work with and refer business back and forth over the years. And it's just a good thing to have, right? So I think a lot of the time your financial planner is sort of pushing you to work on your estate plan, where estate planning attorneys can't as much do that because we don't see you unless you come see us. And so anyway, so the final part of this poll was interesting to me. And it talked about financial behaviors and estate planning, that they tended to differ between gender and wealth levels, which we knew that part's not the interesting part. The interesting part is men were more likely to have an estate plan than women. It's 32% compared to 23%. And they place more importance on having one than women, which was also surprising to me. 74% of men said it was important to have an estate plan, whereas only 67% of women. And typically, in my experience, the women are the ones that are more interested in the long term and the legacy part of things, and making sure people are safe and protected and their kids are protected and the family's protected. So I was surprised that they were talking about how men had the more interest or view that it was more important to have an estate plan. Anyway, we learn things every day, I guess, and that's why we read and that's why we continue to research things. So I just thought that was an interesting plan. I think it ties into what we talked about last week on In the News regarding like percentages of people in estate planning. So there's the In the News segment. Hopefully that's something that's interesting to you guys as listeners. But that's it. That's the end of the episode for today. That's all I've got planned. And so we'll end it there. I'd like to thank you for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. It's your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.